So this is concerning the demonetization. Yes, sir. We are ready, my lord, any date subject to your lordship's convenience. And all others. Does this survive this at this stage?
Milord, what has happened is, Milord, there is an order of your lordships framing several questions.
That's
Nine-
right. In those days, it was very relevant. Does this survive?
But there are two issues, one of which clearly survives. One was the issue regarding the validity. So there were petitions regarding validity. They've brought in an ordinance on 30th of December 2016, trying to give legal validity retrospectively. That was the first issues which were framed by that order of 16 December. But the second was, in that order itself, the court said that no High Court will entertain any petition arising out of the government's decision to demonetize 500 and 1,000 rupees currency notes. So the petitions, there was no 226 remedy available. The Prime Minister, RBI, everybody promised that those who were unable to deposit their notes by 31st of December 2016, they would be given an opportunity till 31st of March 2017 for good reasons. If somebody died, somebody's money was deposited, somebody was abroad throughout the entire period and the money was lying in the house. So therefore the 226 remedy was, and then on the last minute of 30th of December, they brought in an ordinance that we will not take the money. And now, no further. And they brought only two categories in that.
You are arguing. What is
One
the?
second, I'm telling
what
the
is-
live issue. So,
No, the question was only whether anything survives.
yes.
That's.
If anything survives,
So, if your lordship allow me to say something here.
we are only of the view, if nothing survives, then there is no point.
Because there are individual claims apart from
All
the
of you are
constitutional
all of you
validity.
are adamant that something survives.
There are individual claims apart from the validity. Because there are applications filed.
Two aspects.
If your
One
lordship
is,
just see the order dated November 2017.
Mr. Sharma,
there are two aspects of the matter. One is questioning the validity of the action. The second is with regard to the implementation of the same and the problem arising. Now, what has been put is with regard to the survival of the validity as such. The second is if there are problems in the implementations where you have expressed that there were problems who could not exchange the amounts, etc. That is a different aspect. So you'll have to keep.
If your lordship allow me to say something, my lords, there was an order.
Yeah.
3rd of 11,
I would
2017.
earnestly request Mr. Sharma's matter be detailed. So this is the problem on his side and on our side. Both sides are facing. So the answer to your lordship's question is, for all practical purposes, it may not survive. If as academic issues, the honorable bench would like to examine that, we are prepared. Otherwise, my lord, it will not survive. That's the answer.
There are individual applications, your
Five
lordship.
judges spend their time for deciding academic issues.
That's all, my lord, I am submitting, my lord. It need not be.
We are already burdened with so much pending.
So much live matters where rights are involved, my lord.
So, Malad, there were two categories.
May I request your lordship, if your lordship allow me to say
One,
something?
where validity is not questioned.
No.
They were separate initially. The matters in which validity is not questioned, those writ petitions, several orders were passed, and ultimately those writ petitions were said that they will become interveners in this, and their individual grievances will be dealt by the Constitution bench. If that order I have annexed in my
How
IU.
would the constitutional bench deal with the individual grievances? If there is any reference to that will be answered.
Let me submit. Let me submit.
అందుకే పుట్టుకతోనే ఆడపిల్ల అంటారు. ఆడపిల్ల అంటే ఈ పిల్ల
So certain important orders were issued by the Congress, and therefore the central government has also therefore they had allowed the substitution of 1,000 rupees, the denominalized currency for certain reasons. And thereafter, with regard to the withdrawal also, certain enhancement of limits were also.
ఆ వంశానికి చెందిన వారు అవుతారు, గోత్రానికి చెందిన వారు అవుతారు, ఆ ఇంటి పేరుకి చెందిన వారు అవుతారు.
Please listen to us, please listen to us. We will fix it on 12th. Please come on that day. But we are going to examine whether it has become academic in nature, whether it requires consideration at all. This will be the first question,
Yes.
right? Please listen to us. See, we will hear you on that day. 12th, we will fix it. And please come on that day. Let us see how.
Yes, I want to submit one point. Please, Your Lordship, give me a time, give me a chance.
Come and say on that 12th.
Today itself, Your Lordship, then you can examine all that on 12. That's why I just want to say something. I'm not going to argument anything. Your Lordship, there is 58 petition.
Mr. Sharma, are you appearing in person?
Yes, Your Lordship.
Look at your,
I'm not wearing the gown.
you're wearing the band.
Bands.
Oh, you are saying hurriness before the court. You know the advocate always.
What do you mean by hurriness?
No, Your Lordship.
Some decorum has to be maintained.
Just only mistaken. I am removing it. Your Lordship, now permit me. You say there are 58 petitions. Out of them, 57 petitions are civil nature, one petition in criminal nature. Now, Your Lordship, Constitution Bench is to resolve the constitutional issue only. They are not sitting for issuing a procedure, policy, all that part. You have to please put this point. If any petition is having challenge to constitutionality of the ordinance, it should be taken up. If some petition are there for the procedure,
List on 12th.
oblige you.
You come on 12th, you know. We have not disposed of. Come on 12th. Have you dismissed your application now? No. Please come on 12th, let us see on that day. Very deeply of that.
Because India,
So far as item 502 is concerned,
Yes.
my lord, the contours is the freedom of speech and what are the limitations. My lord, your lordships would recall, I will not take names, but one former honorable chief minister made certain remarks with regard to some, my lord, the unfortunate incident of rape having been committed. My lord, according to me, by subsequent judgments, my lord, this law is fairly well settled. But, my lord, we are prepared fully. If your lordships would like to be assisted, what are the contours of freedom of speech?
No, but I saw from the records, the concerned person has apologized and his apologies already accepted. So whether this has also become academic,
Lord,
because he has apologized and apologies accepted here.
Shall I make a very short response to your lordship's query, my lord? I am the next item tagged along with this. My respectful submission to your lordship's query would be this. So this particular case arose from certain statements made by the then minister in Kerala, which was containing disparaging remarks against women, certain employees, laborers, etc., etc. Then the question arose: what is the limit of freedom for the public functionaries? Well, this is an issue which is being repeated again and again. And in fact, in this matter, another bench heard it to some extent, and we even submitted written submissions. That bench cannot be reconstituted, because their lordships, respected lordships, got retained. Now, your lordship may have to address certain fundamental issues like limit of freedom to the constitutional functionaries, including the ministers, the MPs, the MLAs, etc., etc. This is a recurring issue happening here or there, very frequently being repeated. Therefore, I would say, it may not be an academic issue. Your lordship may fix a date. We have, in fact, not made a thorough research on this as to whether the freedom of a minister is akin to a freedom of an ordinary citizen, and how that will affect the constitutional values, if not constitutional rights. But these are the matters which will have to be deliberated. We conducted an extensive research on this. It may not be limited to that UP chief minister's issue alone. Even thereafter, even the central ministers or state government ministers will often repeat this. Therefore, this is an issue of vital importance. And that is the reason for referring this. And the reason for reference still remains relevant.
I appear as an amicus in the matter, and I agree with the learned SG that these are the matters which have always developed case by case, Your Lordships. So in this particular case, the issue was fair investigation, and the person has already apologized. And we filed our written submissions, and this is our submission that these issues have already been decided by Your Lordships in various judgments. The various rights, fundamental rights, they have been balanced inter se. So Your Lordships may take it up, and I think we can show.
So is it the right of only ministers or all other lawmakers? Because whatever statements they make in public, that may have a bearing because ultimately they are the lawmakers.
Correct.
Yes.
Public functionaries, let us
That
not
is
be.
public functionaries, a very broad category, very
Yes.
general category.
No,
Not
even
just ministers.
MLAs and MPs are also public functionaries.
Yes.
So Lordships, this particular aspect is fair
Here
investigation.
incidentally, one of the chief ministers.
Lord, some of the persons, my lord, may or may not be MLA or MP, but still as a leader, he may be in the capacity of a public figure,
There we may not be in
a party president or something. But
is-
the point is this, my lord, whether Article 19(1)(a) and the exception thereto would be differently applied to public functionaries while they are speaking to a larger audience or not. That is the question, which is a live question. Thereafter, my lord, after framing of this question, this is a matter of 2016. The contours are, my lord, defined, as the learned amicus rightly says, on case-to-case basis. And it would essentially be, my lord, it would not be possible for your lordships to lay down straight-jacket line of distinction that you can cross this line and not this line. It would be an individual case where law will have to be invoked. Somebody makes a statement which is, Lord, not strictly in accordance with 19(1)(a), but transgressing his right, freedom of speech. But the question is important, my lord. My learned friend, my lord, has.
Your colleague has done an exhaustive research.
Yes, my lord, we have done the research.
so far as
See,
Available in public domain.
See, right to freedom of speech and expression is essentially against the state. And 19(2) are the reasonable restrictions. Now, if a particular person has made a speech which is not right by somebody else, then that somebody else can always take action. Now, when 19(2) is already there and 19(1)(a) is there can't be some other restrictions over and above 19(2) which can be imposed because the Constitution doesn't recognize that. Therefore, the question is, if anybody is aggrieved by somebody's speech, what action can we take?
Your ladyship's, my lord, your ladyship is absolutely right. My lord, in fact, our written submission is in this line. Or may not be in, because of 19(2), a further restriction, that to a judicial restriction, may be apparently impermissible. But at the same time, when there are horizontal right violation, what else could be done? In fact, my lord, in our written submissions, we have made a suggestion how a constitutional restriction can be made without hampering the constitutional values. This is the purpose. We have suggested a kind of promulgation of self-regulation for public functionaries, borrowing, my lord, certain models from other jurisdictions. We have placed it right from England and from Australia, how the public functionary should behave publicly. That is very important. For example, in the Kerala minister's case.
This is one aspect, please listen to us, but it requires a factual background, right?
That's right.
You can't decide a question in thin air. You need certain facts. On the basis of the facts only, you have to decide.
Each one.
Now, we don't know what the facts are here. Can you lay some general guidelines, without factual background?
so far as Kerala case is
I may
concerned,
answer that. In fact, as far as Kerala case is concerned, this arises
so
from
far
a
as
matter
UP case is
from Kerala
concerned,
High Court.
Just 1 second. What is that?
so far as UP case is concerned, my lord, there has been an investigation. Subsequently, the chief minister apostatized. So far as Kerala case is concerned, once when he was the minister, he made a remarks like this. Then we moved the High Court. High Court said nothing doing. Thereafter, we were granted liberty to come here. and we were granted liberty to get impleaded here.
Who are you? Who are you?
I am for an intervener in Kaushal Kishore's matter. Therefore, that fact remains. Thereafter, what happened is he still goes on making such kind of remarks. Therefore, my lord, this has to happen. So, at least so far as Kerala case is concerned, there has not been an investigation. No investigation happened. No report came.
Does he?
No apologies.
Please listen.
Yes.
Does he deny that allegations made, or does he admit and he says
He admitted, and thereafter.
he asserts is it?
Yes,
He has
he
a right.
asserts it.
He
And
admits and
one
he
such,
said,
one of his remarks ultimately resulted in some other case being reinvestigated, further investigated, and a final report being preferred. He made a submission.
the facts.
This case on 12th November.
12th. Yes,
We have hardly 2 weeks.
Yes, yes, yes.
we have placed
I must say, my lord, as an officer of the court,
facts
that
will be discernible.
only a minute.
1 second. Facts will be discernible from the memorandum itself. Lord, it is stated from
Yes,
page
sir.
F to K.
1 minute, Mr. Consul, please. 1 minute. Oh no, we can have it only.
Saturday.
No, 15 November.
I'm sorry.
November.
Grateful.
List it on 15th, right?
Yes, my lord, I must say, my lord, the threshold of my right as a freedom of expression, speech and expression, if I am in a public leader capacity, would be much higher. There is no doubt about it. A layman can say whatever he wants, and a leader may still not be able to say whatever he wants. But to judicially define that demarcating line would not be, my lord,
It will be
easy
difficult.
exercise.
And it has always to be related to the factual situation.
Factual situation. It will have to be subject to.
Actual situation, my lord, in Kerala case, my lord, has been indicated right to the judgment and even in the SLP, my lord, 3 instances. And after the instances, not only that he didn't deny it, he even reiterated it. He even justified it. My lord, that is a big problem. And similar situations occur elsewhere also. Therefore, this requires a deliberation.
Worships, in this particular case, the issue is fair investigation and balancing the right under Article 21, which is a fair investigation, and right to speech. So, Your Lordships, this issue has already been decided. We'll show it to Your Lordships, and Your Lordships will then examine it and pay the guide.
We will have it on 15th,
Yes.
right?
Yes.
List on 15th.
Yes. My lord, may I make one submission? 107414, I am the intervener. My lord, may ask, my name is not being shown, therefore I will have.
Show his name also.
Yes.
Bribe to vote in a particular manner in Rajya Sabha election. Earlier, there is a judgment, my lord, in case of P. Narasimha Rao, where, my lord, the court took the
I thought it is covered by.
It is covered, my lord, but the
Covered.
court
It is a-
state
It is a, how many judges?
Please to do 5 judges.
5 judges.
Why judgment?
majority, my
I
lord,
thought it covers, squarely covers Narasimha Rao's case.
yes, my lord, the court, my lord, while referring says this, the majority view, while acutely conscious of the seriousness of the offence, felt that the wrongful act and within brackets, sense of indignation of the bench should not lead to a narrow construction of the constitutional provisions which may have the effect of impairing the guarantee to effective parliamentary participation. So, maximum leverage to be given or the right of privilege should be read in its broadest possible term. That was the three honorable judges' view out of five. Thereafter, my lord, the reference says, having considered the matter, we are of the view that having regard to the wide ramification of the question that has arisen, the doubts have raised, and the issue being a matter of substantial public importance, we should be requesting for a reference of the matter to a larger bench, as may be considered appropriate, to hear and decide the issue arising. We order accordingly. Otherwise, the
Rarely covers. And this judgment in even courtroom exchanges also, it applies.
yes, sir. Though our privileges are, my lord, much lower threshold, my lord, but they are not, my lord, the legislators, whether in parliament or legislature, they are not even amenable to contempt jurisdiction. But that's not the question here. Its question is of a criminal offense.
So if your lordship would consider, your lordship would
Or only the question is whether it is the only the act within the house or the entire scope of the act has to be considered.
Yeah, the ladyship is absolute.
Immunity has to be given to the entire act.
yes.
Or only to what happens on the floor of the house.
I commit an offense outside and the result is in the
Yes.
within the house. That is one. So one issue. I am not raising this question, but I am flagging it for your lordship's consideration. So as my lords have rightly said, this is as such covered by P. Narasimha Rao, which is a five-judge bench judgment. And the court felt that considering the seriousness, this needs revisiting. So whether that revisiting would be permissible or possible or at least effective in this combination. Because five-judge view, my lord, your lordships may perhaps, my lord, feel bound by. Though it is 3-2, but now in view of the recent
judgment, you can't
recent
raise
judgment,
that
my
up.
lord, that
You can't find the
numerical
numbers,
it can't go by the numerical strength.
It's a judgment of the bench.
It is a bench, yes, the judgment of the bench.
Let us see on
Great.
15. Even 9.
This is an issue, my lord, which your lordship will have to examine. Hardeep Singh's judgment is already there. According to me, my case is covered by Hardeep's.
This needs, but this is interpretation of section 319 of the Code of Criminal Procedure.
The other
This is my
side,
question.
the other side said that it has to be interpreted. And I said that two judge bench.
At what stage you can invoke 319? That is the
Correct,
question.
That's the
When
question.
the judgment is reserved, when the case is reserved for judgment, can we invoke thereafter?
Yes,
That is the only point.
One, and the last issue which the honorable bench referred was, what are the ingredients to be taken into consideration? Hardeep Singh goes on that also. Even that is answered. Dispute that, the attorney and the solicitor, or even the additional solicitor. But allowing that application, I am opposing.
Why?
The reason is, this is a case under the NDPS Act. It is a case which is by the Punjab government. The parties to the case are only the Punjab government and the accused, or the complainant can come. The Union of India cannot be a party. Your lordship may let that application be, my lord, your lordship, without allowing it. They can address if they want. I cannot stop even otherwise the learned solicitor from addressing. But if your lordship wants to make an order, then please issue a notice. I will file my reply and your lordship may take a view.
So the limited point is this, my lord. When your lordships
reason is, the real reason is, on the basis of this, they have started PMLA proceedings against him. Now, in those PMLA proceedings, they are using the same allegations. So this is a roundabout way of protecting their PMLA proceedings. They have said so in the application also. So this is not an application that somebody wants to genuinely come and help your lordships in interpreting the provisions of law. This is a interest in this litigation, and that interest in this litigation is irrelevant in my respectful submission for the purpose of this matter before your lordships.
But one thing is certain, on account of the pendency of this case, there may be large number of cases pending in the
Not only
Yes.
this, I'll just respond in 2 minutes. Your lordships are not examining the facts of this case. So there is no question of my opposing or supporting him. When your lordships are examining a central statute, that is Criminal Procedure Code, the presence of the central government would really be necessary. That's all I am saying.
Your lordship may allow him to intervene without.
It's the matter on 15th November.
Only one more request. No, there is one matter tagged 504.4. It's a bail matter. My lord. It may be detagged. It may go before a regular bail. This 319 question doesn't arise. Of course, we said that it is.
Who's the petitioner?
I am the petitioner.
My client?
No.
The respondent? No.
No, we said that similar
Bail can go before the regular.
504.4 may go before a regular bail. But this 319 question doesn't arise.
Under D types and listed before the.
This is challenging your bail.
All right, that
319 is not done.
That is delisted, it will go before the appropriate.
But actually, the High Court has granted me bail. I didn't appear. I was just reading their impediment application yesterday evening. In that, they have mentioned, High Court has granted me bail because the High Court says since this matter is pending, they can't finally decide, take a view. So 504 can let it come on 15 November. Your lordship may take it after this is decided, because then if it goes away, then again I will.
Some date may be given. I am not saying. Some date may be given.
But let it remain tagged on that day when your lordship answers.
You already have been granted bail.
I have.
It is my challenge to the bail.
They are
Section-
challenging that.
So let it be considered independently. whether
That's
the-
all, my lord. I'm
Let
saying.
it go, let it
Section
go.
319 doesn't
All
arise.
right, all right.
Why do you want to, the constitution bench to decide whether the bail is rightly granted?
No,
or
no,
not?
I'm only saying it should come after this.
All
After your
right,
lord.
wait, next case.
The next case is under the Prevention of Corruption Act.
4.1 also there is a tag matter with these matters. Not just a suggestion, not other
15
benches
no,
in
sorry,
these group
15
matters are
November.
considering not to apply written submission in advance by parties before assisting the court for better assistance. Your lordship was listed on 15 November. Any parties to make submissions can circulate to submission in advance, as well as your lordship may consider appointing one of the.
You keep that ready on that day, let us see, right?
Just another suggestion. Look, one of the candidates on record are we considered to be appointed as a nodal officer for purpose of compiling everything and placing before your lordship for your lordship's benefit. That may also be considered.
All right, no, for this case, not necessary, what is?
All right.
See, there is no dispute on facts. The only question is whether 319 can be invoked after judgment is being reserved. That is a legal question, that's all.
That's illegal. Facts are not. And your
Facts are
lordship,
not-
even if they are in
And
dispute,
facts we are not going to examine also.
yeah, even if we raise, your lordship would not examine
We
facts.
will not examine the facts. Next case.
But 505, my lord, is a case under the Prevention of Corruption Act.
Yes.
Here, my lord, the complainant, the bribe giver, died. So there is no question of, my lord, proving the illegal demand being made by him. So whether that can be inferred in the trial, because there is nobody who will prove that. So this may not.
No, that is it the only way to prove, or is there any other way to?
That's the question frame.
The
That's
moment he dies, criminal case goes, is it?
it cannot. It cannot unless the accused dies. The question.
Accused dies.
There are two conflicting views, not of three.
True, we have seen that, we have seen that.
Yes, well, that's the question. My lords have been very precise. That's the question. Is it the only way, or there can be other ways of proving?
Bhanumati's odd judgment,
Yes,
of
yes.
order of reference, we have seen that.
Whether there's an inferential deduction that can be drawn.
On,
Inferential deduction, whether it can be drawn.
on any other evidence which is on record.
That's
Yes, but inference may perhaps not be a correct expression because in a criminal trial for punishing someone, you can't do it on inference, but any other mode of proving, that's
Whether a finding can be given with other evidence.
other evidence on record. Now, if you can't
Or
infer,
simply,
Yes.
the complainant dies, the case has to go. That
that can never.
No, not just the death of
A, B, and C comes and deposes that yes, it was taken in my presence, but the complainant turns hostile. What would be the powers of the court to actually?
whether the demand has been proved or only.
Correct.
We will fix it again on 15th, right? We will examine on.
Please.
Item 505.5, my lord.
Hmm.
It needs to be detagged because the primary complainant in this case present across the case, cross-examine, everything has been happened. And trial court has convicted, but high court has acquitted us. So it has been wrongly tagged, my lord, if it can be detagged, my lord.
It will have to wait.
This question has no bearing, is it?
No bearing, my lord. It's IA number 62150, my lord, because primary complainant is there. Entire process, PW 11 in this case. So there is no question, non-availability.
Complainant is available, was available.
My lord, cross-examined everything I heard.
Then I think we have to detect, transfer. Give that number. And speak before the appropriate time.
Duryodhan Sahu.
All, that's all?
Please, sir. Grateful to you. 12th of October, rest
These
15th
cases will be on 15th
November.
November.